Right now, I will lay the floor for Mr. Ashish Kanta Singh and Ms. Ankita Tyagi to take the floor and provide us insights about geographical indication protection in India. Thank you. Thank you, Ashish, and thank you,
Thank you.
Ankita.
Thank you so much, Girish. Yeah.
Thank you, Girish, and welcome once again. Welcome, Ashish, for sparing your time to share your expert insights for our European audience as well as for Indian audience. As nowadays we hear a lot of news about new collaborations coming up and new avenues of global cooperation, especially right now with various geographies, because no innovation or product is going to be just local. It is always aims and inspire as being a global product, wherein IP, as with business strategy, always plays a very significant role in forging new partnerships or evaluating the proposals among partners. And India, there is a lot of buzzword around having new GIs, geographical indications, and
Mhm.
we, with the increased awareness and the government initiatives, especially from Government of India, there are approximately around 643 registered GIs tags across various categories have been registered with Indian Patent Office. And there are a lot of increased interest of industry from Europe side, especially, which includes startups, SMEs, or relevant stakeholders in Europe and India business corridor. So my first question is directed towards knowing more about the GIs, its saline features, and basics around it. Over to you, Ashish.
All right. Yeah. Thank you so much for having me, Ankita. Um, what we can start with is that let's just first understand how GIs are protected in India, and then I'll move to, some of the salient features of the GI Act as it stands today. So, to start with, India has a very strong GI protection regime. And we have a sui generis GI legislation called the Geographical Indication of Goods Registration and Protection Act 1999, which was notified into effect on September 15, 2003. However, even before the act came into force, Indian courts have been protecting unregistered GI even before the GI Act came into force. And even we have, GIs can also be protected through the certification trademark provisions of the Trademarks Act 1999 that can certify the goods, among others, as to the origin and characteristics of the goods. So this is, what one could ask, why the dual, regime for protection of a GI is because you know that the world over there is no uniform mechanism for the protection of GI. Say, for example, in the United States, you do not have a GI legislations, and the GIs are essentially protected through certification trademarks. So fortunately, India provide both the protection scheme either through the sui generis GI legislation or through the certification trademark provisions under the Trademarks Act of 1999. In addition, we also have this the traditional concept of the common law remedy of passing off. The passing off, which has been often resorted to by other foreign entities like the Scotch Whisky Association prior to 2003. That is the year when the GI statute came into effect. So, even before the GI came into force, Scotch Whisky Association has been quite successful in enforcing their rights against, say, terms like Scotch, and they have been successful in injuncting some of the third parties from using terms, not only the term Scotch, but also in some deceptive variants like Scott. And not only that, even some of the evocative terms like Highland Chief, and terms like blended with Scotch, Glen, and rare blend. We also, and including this, some of the device which is evocative of Scotland. So Indian courts have been quite accommodative, I would say, in the regard, and they have recognized the rights of the GI holders in the past, and have provided relief to the GI holders in the past. And so these are some of the examples. Another route where one can actually protect GIs in India is through the border enforcement through customs recordation. We also have this rule coming up, and then so one can actually file this application before the customs authority. So spending a little bit about the kind of cases we have had on Indian soil about the successful enforcement of GI. One of the earliest cases where we have seen the protection of GI is Scotch Whisky Associations against an entity called Dyer Mackin Breweries Limited. So Scotch Whisky Association was able to injunct the term Highland Chief with the device of a Scottish gentleman. So this was one of the landmark case, and followed by another case where SWA effectively took on an entity called Code Distillers. It was before the Bombay High Court, where the use of the term Glenforth was restrained by the court. And similarly, the Goa District Court also restrained an entity from using the term Glenmore, because they said that the term Glen is evocative of Scotland. Not only the Scotch whisky line of judgment, we also have had a very successful stint of GI enforcement with CIVC. CIVC is the body responsible for the protection of champagne, and we have had a very interesting case where CIVC was able to restrain the use of the word Russian River Valley champagne and the California champagne, against this entity called Corbel, and this use of these two terms were restrained. So very often, one can say that it's quite natural to think that whether Indian courts and the Indian GI registry are very friendly to the outsiders. The answer is definitely yes, and as you can see from this plethora of landmark cases, and I will also just try to cover some of them in the subsequent talks. So I just wanted to say that, because this is how GI can be protected in India, and the Indian courts and the system are very, very effective. You also asked about some of the salient features of the GI Act as it stands today. So I'll start from the definition of GI. So the definition of GI in our GI Act is very TRIPS compliant statute. So it has the same essence as a definition of what a GI is as defined under the TRIPS provision, where the reputations is given importance. In fact, the Intellectual Property Appellate Board, the board which was recently abolished under the Tribunals Act, under the Abolition of Tribunals Act. So what had happened was that IPAB, in the famous case Basmati, which our firm was handling this case on behalf of the government of India, held that reputation is actually the standalone factor for protection of a GI in India. And drawing a parallel to that, the GI office rejected an application for Hyderabadi biryani, which is a recipe, this for the benefit of our European audience, which is a rice-based recipe, on the ground that they do not have any reputation whatsoever to, there were no documents filed to support any documentary evidence to support the reputation of Hyderabadi biryani being originated from the state of Hyderabad. So, as I said, the definition of a GI is very self-sufficient and is compliant with the TRIPS provision. So even non-geographical names like, say, Feta, Kawa, I talk about Basmati, in the Pashmina shawls, and Alfonso, these are all names which does not have any geographical connection, and these are not the name of a place in India or anywhere in the world. So these kinds of names are also registrable. So it's not only that only the geographical names are registrable. The kind of goods which can be protected under the GI Act includes not only the agricultural goods, but also manufactured goods, natural goods, handicrafts, and foodstuffs. These are all eligible for registrations. And, it will be of interest to the European audience to note that in Europe also recently, into the 2023, you have a new regulation of 2023/2411 for the protection of crafts and the industrial product. So in India, in fact, Ankita mentioned about 463 GIs registered in India. In fact, 68% of those GIs currently registered in India, they all pertain to handicrafts product. So it is quite interesting that this European regulation has come at the right time. This will throw the door open for many of the Indian artisans who are seeking, or the bodies who are seeking to register their GIs in India, in the European Union, and also for the European SMEs and the other European body, we already have this act which provides enough protection for the registration of handicrafts. The definition of producers, that who are producers of a GI in India, are pretty broad, and it even include not only the producer in the strict sense of the term, but also the processors, those people who pack the product, the traders, and practically all those who are involved in the entire supply chain of a particular product. So these are all collectively can be termed as the producer of a product. Uh, Another important provision which I can really touch upon is we also have a provision which is very similar to Article 23 of TRIPS, which provides for special protection for wines and spirits. But in India, what is interesting is that it's not only confined to wines and spirits, but it's also available for all category of goods. So if it's been notified by the government of India through an official journal that this is a special product which is which should be recognized and also should be afforded an additional protection, the government of India can do that by giving it through a notification. One of the prerequisites for being an applicant is that the applicant must necessarily represent the interests of the producers. And in fact, when you file a GI application, the GI registry will ask for an affidavit from the applicant to give you an affidavit as to how the applicant represents the interests of the producers. In case of any violation of a GI in India, the GI Act provides for the civil remedy of infringement, which also includes an ambit of unfair trade competition. The Act also provides civil remedy, as I said about earlier. The Act also provides civil remedy under the passing off regime, and also there are certain criminal provisions available under the GI Act, pertaining to say falsification of the GI and falsely applying the GI. These are all punishable offense under the Act, and even the subsequent offense will attract higher penalty. One of the important provision which I think which we can keep in mind is that which comes into rescue for most of the big European players in India, including CIVC and also like Parmigiano Reggiano cheese, Chianti wines, etc. So what they do is that in India, there is a provision called Section 25 of the GI Act. So the GI Act basically, Section 25 basically mandates the registrar of trademarks to refuse or invalidate a trademark if that trademark consists of or contains a GI, and if such GI in the trademark is used in a misleading manner. All right. So at the time of examination of a trademark, the trademark registrar is given a mandate to refuse or invalidate any registered trademark if it contains a GI in a misleading manner. Okay. And also if the trademark application contains a GI that has already received an additional protection under the GI Act. So these are the special provisions, which is generally invoked by most of the big stakeholders here in India, and this is one of the primary ground why we file the notice of oppositions against any third-party trademark applications in India. Yeah. So these are, I think, I think we can say that these are some of the salient features for the purpose of for the benefit of the European audience.
Indeed, it's very interesting and very intriguing figures, because the trade figures and the facts you have stated, it clearly demonstrates that GI is a very powerful tool for boosting the trades, collaborations, cooperations, and protecting the traditional knowledge, culture, and also socio-economic development. And legal frameworks are already available in both jurisdictions in Europe as well as in India under IPR, intellectual property rights umbrella.